Let's finish our second fulfillment of today's class. In this case, as you already seen, in this case, the issue will be how we evaluate the disagreements between intention and consequences. Even though there was no exact matches between the intention and consequences, we still allow to call there was an intentional consequence. It is because we evaluate that. The Korean called things like that. A want to kill another person by shooting, and even though the person who was intended was not killed, still a human being was killed. Then we have to say that there was an intentional killing. There was a murder. These evaluations of mistake can be called as the different side of same coins of issue of intention, subjective requirements of elements. We need always subjective requirements to acknowledge there was guilty acts, there was a guilty consequences. So we can say that if an actor had a mistake of factor, if an actor is considered to be involved with the mistake of fact, he or she cannot be convicted with an intended crime. The exact definition of the mistake of facts is a misunderstanding of a circumstance that belongs to the criminal element in question. Let's move to case 6. That is similar to case 5, but it's slightly different from case 5. A should be with his rifle, but the bullet fired must be, but hit a bear, not a human being, which stood 100 behind B. Then bear died on the spot. How are we gonna evaluate this case? Was there a murder? Yes, there was a intention of murder, intention of killing a person. But the real consequence was not murdering a person, killing a person, killing a bear. Killing a bear. It must be crazy. It must be considered as a crazy person who, if you argue that this case is about there was a murder happens. There happens murder in this case. If you must be considered as a crazy person, yes, based on your sense of justice, there was based on the common sense of Korean society, we cannot say that there was a murder, there was a intentional killing in this case, because intended consequences does not happen. Bear died, not human being died. In this case, we cannot evaluate the phenomenon of killing a bear was the consequences of intention of killing a person. We cannot say that. It's not an unreasonable evaluation. So the intention of killing a person was not actualized, realized as a matter of consequence, and objective requirements of a murder, then we cannot say that there was a murder. We can just say that there was attempted murder. There was no consequence. Then attempted murder happened. That is reasonable. That's reasonable. So what about the killing of bear? The consequences of killing bear is not related to intention, but related to at most negligence killing of bear. But there's no criminal provisions of negligent killing of the animal. That kind of negligent killing of animals. If you killed another person's pets, dogs or cats that belongs to another person's, then you can just have the responsibility to pay damage to the owner of the cat or dog. So criminally, as a matter of criminal law, you don't need to take responsibility for the killing of bear. So we can pick up the issue of the case 6. The issue is whether A can be convicted with a murder of B. If not, which crime shall be convicted? If a person's criminal intention is not considered to be connected with a harm that happened after his or her act, his or she shall be punished with attempted acts in which he or she intended harmful consequences. Now you have an intention. You have act to realize that intention. Then the energy of crime already expressed the outside of the world. It should be evaluated. So we call that kind of phenomenon as attempted crime, which does not relate to the consequences that happen. No, in other words, no matter how serious is the consequence that actually happened, the consequence is not relevant. If that harmful consequence is not determined to result from an act. So we always think about fault and consequences and connection between them. That is cause and effect. There's that kind of perspective is also, in one sense, is related to substantive requirements, but also related to objective requirements, especially causation. Causation is also about the relation between cause, intended or negligent acts, and the effect, consequences, harmful consequences. All right. You are criminally responsible as long as you, insofar as, to the extent that you have any fault on the harm. You need fault to blame a person, to criminally blame a person as a matter of the consequences or harm. It is called, in German, it is called as principle of Schuldprinzip. Schuldprinzip. It's very hard to translate in English. It's principle of criminal responsibility, probably. So now we finished our assignment of today about general parts of substantive criminal law. Then so why don't we move to specific part of substantive criminal law? Still, we are going to deal with a particular case to understand how in the criminal law deal with the requirements, conceptual requirements. Let me read the case. A is B's son. B has long suffered from kidney disease. One day, A sneaked in having C take some sleeping tablets. After C fell into the unconsciousness, A cut off C's kidney and wrote "Go to hospital" on C's body. What is the issue? You always have to think about the issue, all right? Let me give you a tip about the issue of this case. The issue of the case relates, on the one hand, theft. On the other hand, injury. All right? Think about that. Write down your issues on the paper. And then listen to my explanation. So now, think about that. Can you sell your kidney in the market? Can you sell your kidney in the market? Probably some country allows people to transact with their internal organ, physical organ, but most of the countries prohibit the transaction of internal organ. So kidney, you cannot sell kidney in the normal market, but still in the dark market, you can sell kidney in a very high price. As I understand it, more than probably $10,000. Yeah, probably more than that. So $100,000. But yes, you can exchange your kidney into money. That it can have the market value, all right? Even though that transaction is prohibited in law. No. Then, can we say A's X is considered as theft? Yes, A thieves sees kidney. As a matter of our everyday, based on our everyday languages. Also, he has kind of conscience. He wrote "Go to hospital, please," on the cis body. Issue first: can cis body part, the kidney, be the object of theft? Yes, this is the more analytical approaches of this issue. The kidney should be analyzed to become whether it can be object of theft, objects of a criminal acts is one of the objective requirements of elements. So can you say C's body part be an object of fifth? Issue second. Then if not, it sounds a little bit strange, as my body part can be object of fifth. Somebody cuts my hair, and he take it away to sell in the market. Is that a kind of theft? What about my legs? My arms? If not, which criminal element is satisfied by A's acts of taking C's kidney? I've already given you a tip. I already give you a hint. Yes, you can say there was two criminal provision. The first one is Korean Criminal Code Article 329. There was a theft. There was theft. And also you have to go to Article 329. You have to evaluate this case between these two examples. Oh, no. I mean, all right. Based on, if a person take away another property without consent, he or she shall be subject to less than 6 year imprisonment and less than 10 million won fine. One is Korean currencies. The one fine. But a human body part that was not removed from his or her body cannot be another's property within the meaning of a Korean Criminal Code 329. But if you go to the another, injury provisions of Korean Criminal Code, you can find out this one. If a person inflicts an injury on another's body, he or she shall be subject to less than 7 year imprisonment. Yes, these provisions can be applied to the case somebody who steal other people's body part by cutting or by way of surgery or any other means. Then we can expand our questions further. What about the case in which A steals B's kidney that was donated by C and stored in the hospital X? It's already separate from somebody's body. That organ can that organ become the object of theft? Yes, even though you cannot legally steal, you cannot legally sell that organ in the market. It can be considered as an object of theft. So once separate from somebody's body, that body part can become the object of theft. So we can say that the separated body part is a property under the meaning of 329. So now we already deal with substance. We finished. We complete the Korean substantive criminal law, including general part and specific part. you finished, you master the Korean substantive criminal law. Actually, this, the substantive criminal law and specific part of criminal law are dealt with in my class, usually on the undergraduate school for 3 semesters. But you are genius, I think. You finished it in the within 30 minutes or 20 or 30 minutes. So why don't we move to criminal procedural part? There are stages. If you divide the criminal procedure, the first one, investigation. The starting parts of criminal procedure, and after that, based on the materials, based on the informations gotten from a investigation, the prosecutor have to decide whether that case should be prosecuted or not. And if the case was prosecuted, you have to go to the trial. It means court process starts. From the trial stages, the courts dominates. The court has power to reside all the process, and then the conviction after the trial, jury decide to convict or not, and after the jury's decision of conviction, the judge decide to sentence what kinds of level is proper to a particular person who committed a crime. So investigation is involved with police and the prosecutor. On the one hand, they are investigator. On the other hand, investigation involves suspect, defendant, and defense counsel. They are adversarially structured against each other. Yes, of course, the police and prosecutors want to get more information, and especially want to get confession from the suspect or defendants. But suspect and defendant counsel try to escape from the being involved with the guilty. So that conflict, a serious interest conflict between police and investigators and defendants are reflected on the many rules and standards of criminal procedure, because investigator, even though they has a lot of high level of convictions about a case, they still need to keep due process to get a conviction, to get a confession, or to get some more information from the suspect and defendant. Suspect defendant has usually they do not know in details about criminal procedure and investigations. They saw, the law allow them to have a counsel to help them themselves about investigative process. After the investigation, prosecutors against defendant and still defense counsel have to decide whether he or she prosecuted this case based on the information and a lot of documents and confessions from defendant or any other people involved with a criminal case. And then if the case is prosecuted, you have to go to the trial. Trial means court process, open court process. In these stages, judge and jury appear. They are preside over the process. Prosecutors become one side, prosecutors occupied one side, and the other side is occupied by the defendant and counsel. And judge and jury is the real, really preside over the process, and they decide the decision whether that person pointed by the prosecutor as criminal is guilty or not. And after the trial, jury is not one or two people. Usually there are 12 personnel get together, and they decide. They talk with each other, and they sometimes they argue against each other, and they have to reach one conclusion unanimously. They have to one conclusion of guilty. If they did not reach the unanimous decision of guilt, they have to declare this case should be not guilty. This particular defendant is not guilty. If the jury declare not guilty, particular defendant not guilty, still judge can convict that defendant is guilty. It's a little bit different from the English, UK or United States, from Korean system. You have to distinguish. Korea do not adopt the absolute power of jury to declare guilty. We divide the power. We give the partly, let the jury decide whether a particular case is guilty or not, and also we still do not, give up the judge's power to declare guilty or not. So, even though jury do not think a person is guilty, still judge can decide a person is guilty. The reverse is possible still. And after a person is convicted guilty, decided guilty, then jury and judge get together and then think about and decide about the sentencing. Sentencing means a court declare particular level of punishments for a particular defendant. In this way, criminal procedure can be wrapped up. Think about criminal procedure. The based on the fundamental rights. I always emphasize. A policeman called B on the phone to ask B to stop by A's office. B voluntarily came to the police statements. In the interrogation room, A asked B to confess on the fact of B's robbery by giving the psychological pressure that is not unlawful. B told that he wanted to call his lawyer. A allowed B call his own counsel. Before B's lawyer arrived, B did confess on his crime without any pressure, without any unfair pressure. A wrote B's confession on the affidavit and get in the courtroom. B was convicted. As that, what is the issue of this case? Still, spotting the issue is the most important part to think about this case. Issue first, can voluntary confession be used as evidence to prove he is guilty in the courtroom? Was B's confession was voluntary? Voluntary? Yeah, that is first issue. To be a confession involuntary, to decide on confession involuntary, we need unfair pressure from investigators, police or prosecutors. Can you find there was an unfair pressure? Which is not allowed. It's not lawful. Which is not legal. Can you find that kind of unfair pressure from policemen? I don't think so. There was a psychological pressure, but it's not lawful. And also, the policeman allows the defendant to call his counsel. B looks voluntary to confess his crime to the police. But still, we need to examine in more details about lawfulness of A's interrogation. Is there any unlawfulness in A's interrogation? Yeah, there's the kind of standards in Korean criminal procedure. Korean Code of Criminal Procedure 224-3, a prosecutor or police officer should provide Miranda warning, such as right to remain silent, right to counsel, before he or she interrogate a suspect or defendants. The Korean Criminal Code of Criminal Procedure protects the defendants more in details and more strongly than the American and the United States system, because as a matter of providing Miranda warning, you need arresting a person's circumstances. So in the United States, the Supreme Courts declare that only when a police arrest a particular defendant, you need to provide Miranda warning. But in this case, there's no arrest. He just voluntarily followed the policeman to the police station. So we can say that Korean Code of Criminal Procedure uniquely protects the defendants who are not subject to arrest, by way of requiring to give Miranda warning before getting confession. Without Miranda warning, any kinds of confession from defendant is invalid. It's violating fundamental rights. What kind of fundamental rights? Without Miranda warning, confession is per se is considered as involuntary based on Korean Criminal Code. So now, why don't we move to, let us wrap up the part of criminal procedure. Let's move to real part of public law, such as administrative law. There are tons of the millions of criminal statutes about administrative law. Still, these days, in every day, more than 2 statutes are enacted, legislated in the Korean by the Korean legislators. There are Code of Public Election, the Code of Antitrust, the Code of Medical Care Insurance, Code of Traffic, the Code of Environmental Protection, Code of Police Duty and Right. It is not exhaustive example. I myself, even though I'm usually considered as expert of law, still I don't know how many, what kind of statute, how many statutes has been legislated in the Korean Congress. I don't know the exact number. There are tons of, as I understand. Yes, there's administrative law, the Fishery Acts, the Act of Quality Control of Fishery Products, your area, the Act of Accidental Insurance for Cultural Fisher Products, the Marine Insurance Laws, Act of Rescue and Aid at Sea and in the river. These are all about administrative law. These acts are related to your area. So your area is mainly about the public law in Korean legal system. Korean administrative law largely is considered to be equal to Korean public law. But in the narrow sense, Korean administrative law is a set of the law of structure and the functions of governmental bodies and organizations. Also, it contains the law of administrative process of relief on the violation of right of a citizen. Based on the Code of Traffic, let me raise the example of the Code of Traffic. Based on the Code of Traffic, a fine placed on a traffic violator by a policeman is not a kind of criminal punishment. It is monetary sanction, but it's not a criminal punishment, but a penalty of an administrative measure. Therefore, you don't need to receive any notification from a prosecutor, and you will not have any right to be silent or right to counsel, etc., which are usually secured in criminal procedure as a matter of the fundamental rights. Many statutes, there exists a kind of fine that can be placed by administrative body that has a relevant power. That kind of monetary penalty is not classified as criminal punishment, but administrative measure or penalty. There remains no criminal record, even though a violator was fined against his voluntary will. So it is administrative sanction, administrative monetary sanction. So it's subject not to criminal procedure, the rule of criminal procedure, but to rule of administrative law. Let us see our another case, case 9. A man tried to commit a suicide in the downtown by falling down from a tall building to the ground. A policeman found the man standing on the edge side of the roof of the building. The officer carefully approached and caught him out of the danger. Although the man begged for the let him alone, the police rejected and brought him to the police station. How it is possible? Based on what authoritative power? Basically, policeman has a power to investigate a crime that happened in the past. Investigating a crime means investigating an event in the past, happened in the past. The administrative function, police also played a role in the administrative function. So the administrative function of police makes it possible to protect a citizen by eradicating any kind of danger with his or her authority and might, which seems to possibly happen. The Code of Police Duty and Rights, Article 2nd. So by way of administrative power, police protects citizens from the danger which might happen in the future. Unlike the power is based on the criminal procedure to investigate a crime. A allegedly made a sexual insult on his subordinate worker B in S University. The chairman of C of the disciplinary committees in S University hands out the written statement of B to the committee members without any notification to A. They decided to place A on 1 month suspension of his work. What is the issue of the case? What was the violation in this issue? In this case, there was no issue of criminal prosecution, but it is about administrative sanction against a particular person who worked for a university. Although Korean administrative law consists of piles of statutes and rules and regulations that make restriction on citizens, every single citizen has a liberty interest against a disadvantageous actions placed by the administrative body. So, even though administrative body clearly identified a fault and unlawful acts happened in the past, they cannot place a sanction on the person without any supporting, without any providing due process. Every single citizen has a fundamental right to be notified and heard before an administrative body, which placed any restriction on his her right or interest. Right? Notification here is the key factor to keep the due process in the way about the administrative sanction. Let's move to your area. The Fishery Act is also, as I already mentioned, already explained, is part of administrative statutes. And the Fishery Act, why don't we read about Article 1st? And in the Article 1st, there was a purpose of this act. This act provides a basic system of fishery to effectively use fishery resources and to advance productivity of fishery to support democratic development of fishery. And let me read these articles. Article 8, a person who does a particular type of fishery such as stationary, net fishery, and villages fishery shall get a license from a local government. That is regulative and administrative restriction on the fishery, right? And let me read Article 17. A right to fishery as a sort of property right shall be registered on the fishery register book. And also Article 88. Korean Ministry of Ocean and Fisheries shall set up the Committee of Fishery Mediation. that will deal with the cases and controversies of fishery. Yes, ocean, ocean and sea does not have so, clear boundary, you know, with an eye with an eye on normal, people. So there always happens conflicts and controversies about the fisheries. And, to cope with that conflict and that case and controversies, Korean ministry set up the process and organizations. 86, Article 86. If a person run a fishery without getting a relevant right, he or she shall be subject to less than 3-year imprisonment or less than 30 million won fine. Yes, this is provisions regarding criminal punishments, not administrative sanction. So, if you want to sanction a person based on the 1907, you need formal criminal procedure. You have to keep all the due process rule and standards codified in the code of criminal procedure and so many other statutes and also so regarding court cases. And Article 17, if a person does not notify his waiver of fishery to a relevant local government, he or she shall be subject to administrative penalty of less than 2 million won. 2 million won. Yes, this is about administrative sanction. It's not criminal punishments. So you don't need to be subject to the rules and standards of criminal procedure. However, still you need to keep the due process of administrative law. What is core of that? Notification and hearing as key part of due process in the administrative law. Yes, usually the level of sanction is lower than criminal fine, right? All right. Then I can say that we are finishing and wraps up all the substance and contents of today's class. I hope that as my lecturer has been helping you to understand, helping you to better understand the Korean system of public law, and I hope that you have the bright future in your career, and hopefully we can meet in the next times with my another class. Thank you very much. Good luck.